we'll take it under advisement. So thank you both, and we will immediately go to the other case, which is
Thank you, Your Honors.
thank you.
Yes, thank you.
You both are excused, and we will now go to the Jefferson Faustin versus the people of the Virgin Islands, number 107, 2022. And you have Attorney Adam Christian and Tracy Ann Myers. Okay.
Good morning, Your Honors.
Good morning, Attorney Christian. As the appellant, you wish to reserve any of your 15 minutes for rebuttal?
Yes, Your Honor, I wish to reserve 3 minutes.
Okay. And as with the other case, you will get 2 minutes uninterrupted, each of you, to make your best arguments uninterrupted and before any questions are asked. So you may proceed. You may proceed.
Thank you, Your Honor. May it please the court, Adam Christian of Ogletree Deacons, court appointed to represent Jefferson Faustin, the appellant in this interlocutory appeal. In this appeal, the court is again called upon to emphasize and remind the trial court that decisions with respect to release conditions, including bail, whether at the initial hearings or at requests either by the prosecution or the defense to modify conditions, have to be individualized as to both the person and to the circumstances, and that any resulting order has to be connected to the purposes of Rule 5-1 with respect to release conditions, meaning that ensuring the defendant will appear in court, that the defendant is not a risk to a member of the public, and that's a risk of physical harm, or that the defendant is somehow undermining the integrity of the judicial process. None of that is present in this case. If you go back to the November 2021 order of Judge Francois, where she initially set out the release conditions for Mr. Faustin, she went to great lengths to point out he has no prior criminal record. He was a member of the National Guard. He started a scholarship fund. The only people who testified were presented by the defense and testified that they had no experience with him doing anything wrong, that he had absolutely no criminal record. And he was eventually released in February of 2022. Between February of 2022 and November of 2022, when he was again remanded, the court conducted 3 hearings in his case. He appeared for all of them. At the November 2022 hearing, the only violation—
After his release, there was only one pretrial conference, right?
There was one pretrial conference. Then there was a hearing in October on the initial motion of the government to revoke his bail, which had to be continued because the government hadn't provided the underlying videotape of their sole witness. And then he appeared for the actual hearing. So those are 3 different times that he was ordered to appear and in fact appeared. So that's what's in the record. The only violation that was established on the record was a curfew violation, that he was out after 6 o'clock p.m. When he should have been at the home of the third-party custodian. Based on that—
But you said the only— isn't that a violation?
Oh, we conceded that was a violation. We conceded that. The question becomes, after finding that there was a violation, what is the remedy? And if this order is allowed to stand, then simply every single violation of a pretrial release order authorizes the incarceration of the defendant pending trial, no matter how minor it is, no matter whether it's connected to the defendant's appearance record, whether or not it's connected to any threat to the society. There
Well,
was
let me
no
ask you this,
Well,
attorney.
didn't the
Attorney,
court in this case rule that, that it could not, if he couldn't abide by, you know, a clear-cut curfew, by, you know, curfew, that it could not, it didn't have any confidence that he would abide by anything else, then isn't that enough of a finding?
I don't believe so, Your Honor, because we suggested to the court a reprimand, we suggested a fine. The court had the option to perhaps sentence him to a period of time of incarceration, all with the aim of getting him to comply with the release order. The court did not explain why it didn't believe that payment of a fine, a financial burden, would not achieve that.
well, let me
And-
ask you this, attorney. You, the thrust of your arguments on appeal, I believe, is basically twofold. One, you are saying that because it was not an innocuous violation, but a de minimis violation, he was seen at a certain hour when he should have been with Mr. Shahil. And Shahil is in Mandal, and he was seen at Estate Lovenloot. But I get the same impression that you're saying that because he was he was incarcerated for an indefinite time vis-a-vis until trial, when the judge in her order said, if you had, in his first order said, if you violate my order, you may, and I underline and underscore may, and you may be remanded to the Bureau of Corrections. But the judge, when on the issue before us, you have raised the issue of abuse of discretion, and you're saying that it was an abuse of discretion, given that what he had done in comparison to the penalty that he has. Because am I correct? He's still in jail right now as I speak.
Yes, Your Honor, he remains in
And
custody
he's
of the
in
Bureau of
jail for
Corrections.
about how many months now?
Since November of 22, so
Yeah.
9
all right.
months.
About 7, 8, he's 7, 8 months. And you're saying that when the judge, and is there a trial date set in this case?
There was one, Your Honor. I
But
recently
right
filed.
now, there is none, so that under the judge's order, unless we do something, he can go on and on indefinitely for the next 6 months or maybe a year in jail. And you're saying there was an abuse of discretion when the judge sentenced him to incarceration pending trial, basically.
That is correct, Your Honor, in two respects. One, it appears that the judge simply wanted to punish him for what he did, which would mean the
All right,
procedures
so
of Rule
basically,
42 would have to come into effect,
basically
which
you're
were
saying
not followed.
that the punishment is draconian, because she could have given him a week, 2 weeks, 3 weeks, or maybe a fine, a reprimand, give him a second chance, because he was seen coming from the apartment of the lady that he supposedly was living with, that he is assisting with his support, and who has a child for him. And therefore he was in violation. This is a curfew violation as opposed to a violation of committing another crime.
That's absolutely correct, Your Honor. It is a curfew violation, and it's not even there was no evidence that he was actually residing with her at the time. What Mr.
What he was visiting his young daughter?
He has a child with Ms. Fred, separate and apart from the complainant. And he was at the home after 6 p.m. But there's no testimony in the record that he was actually living there. The government seemed to allege that in their motion, but there was no evidence put on at the hearing that he was actually residing there.
In other words, it is just that the father of Ms. Fred's 2 older children were returning the children to Ms. Fred's apartment at Estate Lovenloot, and he saw the defendant coming from the downstairs up, went to her SUV, came out, went down into the apartment. And at this point in time, he already had a curfew order to be in Estate Mandal with Mr. Shahil, with the third-party custodian. And you're saying that for that small thing, for that violation, because I didn't get the impression that there was any denial that there was a violation of the order.
We conceded that at the hearing, Your Honor, and we
Right,
continue to concede that.
but it's a penalty that you have a problem with.
I-
And also depending your third motion for bail because he wants to attend church and pursue his musical career, that's still pending down in the trial court. So that's basically the two issues that you have before us.
Well, no, that motion was denied as moot after the judge revoked his bail. I'm submitting that that was in error also because his bail should never have been revoked. And that the court should have actually considered that on the merits, keeping in mind the defendant's right under the First Amendment to exercise freedom of religion, as well as his liberty right to pursue his livelihood.
Attorney Christian,
Yes, Your Honor.
regarding Rule 5-1, you argued that there's a duty on the part of, well, both lawyers, once they're filing a motion to modify conditions of release, to confer, and that this did not occur in this case. What is the consequence of a failure to confer?
Well, I think if the attorneys do not confer, the motion does not comply with the plain language of the rule, and the trial court should simply deny it out of hand.
Let me ask you, did you bring this to the trial court's attention?
I believe I did. I'm not 100% certain, Your Honor.
I don't think so.
Okay, I may be wrong.
All right, well then, with regard to the court's order, we know that there's an abuse of discretion standard. Your argument is that there was an abuse of discretion because basically, as I understand your argument, there was a single violation of the court's order. So to use Justice Swan's word, I think that may have been a draconian response, if I understand your argument correctly. Are you not also, in fact, you seem to be arguing that this was a de facto detention?
Well, that's what actually results. He has now been denied bail for a non-murder case, which is against the revised organic act.
According to you, to your argument, what the trial court should have done is, okay, I revoke bail, and then she begins setting a new bail with new conditions.
I think
What your argument?
My argument is that the court needs to look at what the violation is and the circumstances surrounding it, and then fashion an order, keeping in mind that the presumption is that defendants are supposed to be on release. Now, that can involve adjusting the amount of bail, that can involve setting additional conditions of release. As I said earlier, if the court wanted to show that it meant business and wanted him to comply, setting him to jail for 5 days and saying, look, we're not playing around. All of those things are geared towards getting compliance, which is what civil contempt is about. Simply remanding him without any bail whatsoever not only violates the Organic Act, because this is not a murder case, it's also, in my view, the equivalent of holding him in criminal contempt. And since that would require using the procedures of Rule 42, and that did not in fact happen, then the court was in error in that respect also. What we have is the man was out one single time after hours. There's no evidence that anything else happened. No one said he was a threat to any of the children or even hinted at it. No one said that he repeatedly did it. The remedy is so far removed from what actually happened and what was in the record that this was an abuse of discretion because the court didn't explain why his appearance at the other 3 hearings didn't count for anything. Why a fine wouldn't work, why some other remedy wouldn't work. The presumption is he's supposed to be on release on the least restrictive conditions. And that does not mean the court can't enforce its order. But when it does so, it has to do so being mindful of the presumption of release that's in 5-1.
Should this be looked at more as a contempt proceeding? To say that is a denial of bail. I mean, he was granted bail, he was out, and he violated the terms and conditions of his release, and the court basically remanded him. You know, how many chances is the court required to give? How many, you know, what is it supposed to look at as being a serious violation? You know, I can tell you that I, as a trial judge, released someone from detention when that was allowed, with a 6 p.m. to 6 a.m. curfew. And at 8 o'clock, almost the same time that you have here, that defendant driving with his girlfriend and a young kid in the back and in a car seat, at 8 o'clock, the same violation, when someone opened fire on the vehicle and the kid in the car seat was killed. So, you know, how are you supposed to weigh the, you know, just how much leeway is the court supposed to give? And if you can't abide by a simple curfew violation condition, I mean, why is the court required to continually release you and release you and release you, hoping that somehow you get the result? You know,
well,
so.
Your Honor, to answer the first question, yes, I believe this is a contempt proceeding, and it's a civil contempt proceeding. And we conceded that there was a violation of the curfew provision. That's not disputed. I think what Your Honor is suggesting is that the court must allow continuous repeated violations. That's not what happened here. We have a
But how do you know?
violation.
This is the first one. You're supposed to allow like 5 or 6 before you get serious?
Well, because what the trial court has to do is rule on the evidence before it. The court can't assume that there were several other violations. In fact, the government made allegations about residents. They didn't put any evidence on about that, which would have been a separate violation.
But wasn't there evidence, at least, wasn't there evidence from the other kids that he had been there for several days?
No, they only said that he had been there. They didn't say how many, and in fact, that was the statement of the father. What the government argued in its motion was that he had been staying there continuously. No such evidence ever got into the record. So
but there was evidence from the father that the kids told him that he was there.
That he was in the house. That night, there was no indication from the complainant about his children telling him and then him putting in the record how long he had been there, whether it had been several days, was he there every weekend? All they said was, yeah, he was there. First, that was in fact him, and that yes, he was there. The government didn't put on the evidence, so there was nothing for the court to consider in finding any other violation. And I think going from bail and conditions to a complete revocation of bail and all conditions for a curfew violation without any other explanation, without any other evidence in the record, and no clear explanation of why that's really necessary, it is an abuse of discretion. And again, it's tantamount to detaining Mr. Faustin in a non-murder case, which is not allowed under the revised Organic Act.
Well, did not the trial court explain that this was not just, well, these are not the trial court's words, but basically the trial court explained this is not simply a curfew violation. The defendant went to a household where there are minor children, and there's an order that he's not supposed to be alone with minor children. Now, the court's concern was that there is a protected class of children, specifically teenage girls, and that the likelihood that not the likelihood, there are teenage girls living in that home, and he is there beyond curfew hours. There's nothing in the record to indicate that there was an adult in the home at the time. So, I mean, how is the court supposed to, these are all factors that the court was allowed to weigh.
Well, Your Honor, that's the court did in its initial order and reiterated at the hearing that it was concerned about Mr. Faustin being around minor females in particular, and fashioned an order that he was not to be around minors alone. If the government is asserting that he was alone with children, then they have the burden of showing that he was in fact alone. The complainant, Mr. Julius, brought his children home to be with Miss Fred. So the natural inference is that she was home, not that there was a violation of him being at home alone with the minors. There was no evidence in the record of that. So there was no violation in that respect. In that respect, there's nothing that says he violated that. The only thing is he was out after 6 p.m. If the government believed that there were other violations, it was the government's duty to put on that evidence, because ultimately the trial court's decision has to be based on what's in the hearing record. And what's in the hearing record supports nothing other than a finding that Mr. Faustin violated the curfew with no other complications, and that he had appeared at all other hearings since he'd been released, that no one ever accused him of being involved in any crime, that no one ever accused him of committing any sort of presenting any sort of harm to anybody. In fact, at the initial hearing, Ms. Fred testified, and Judge Francois noted that in her November 2021 findings, that Ms. Fred said he'd been a wonderful stepfather to them. So there's nothing, and the government didn't put anything on to change that finding. So the court making those sorts of assumptions, I think those are clearly erroneous factual findings and can't support the decision that was made.
Okay, thank you. Attorney Myers, you may proceed. Well, let's get the time squared away for you, 15 minutes. Okay, you may proceed.
Good morning, and may it please the court. My name is Attorney Tracy Myers, and I'm an Assistant Attorney General here on behalf of the people of the Virgin Islands. The Superior Court had fashioned Faustin's release condition, including his curfew, after finding that he was both a risk to the community, particularly minor children, and a risk of absconding. Although Faustin could have visited with his daughter and girlfriend anywhere on island, Faustin admittedly violated his curfew in the home of 4 minor children shortly after he made bail. In fact, the Superior Court indicated that Faustin's curfew was designed to limit his contact with minor girls, given the allegations that Faustin physically overpowered and raped a minor child who was too scared to yell for help because she was afraid of what he would do. Faustin's own motion to reside with Fred asked for the restriction against being alone with minors to be removed as a consequence of that request. With one exception, all persons are bailable by sufficient sureties under the Revised Organic Act. But the Revised Organic Act does not place a similar restriction on a court's ability to revoke bail when a person charged with a dangerous crime shows that he will present a danger to the community or abscond. The trial court should not be required to wait until a defendant actually commits a crime in order that they be detained. While this court has yet had occasion to address the legal standards for revocation, the government asked this court to hold that Section 3504A of Title V already applies to all pretrial detention of persons charged with a dangerous crime, and that trial judges be given great deference to decide issues of bail revocation because of their direct familiarity with the defendant and the case. The government asks that this court conclude that we already have a statute governing revocation of bail, and that section 3504A is the best rule for the people of the Virgin Islands, and that Faustin was properly detained under this statute. Rule 46 indicates that Rule 5-1 governs pretrial detention. Rule 5-1 is subject to any specific statutory provision, and unlike Rule 5-1, Section 3504A specifically deals with pretrial detention. Under Section 3504A, if a person was previously released, a prosecuting attorney may initiate a pretrial detention hearing ex parte. The section requires the government to certify that based on a list of factors that
Would that apply? Didn't this court rule that detention cannot apply to non-first degree murder defendants? So you continue to use that section, which I think we did say that it could, that the courts can use the elements in fashioning release for non-first degree murder cases. But, I would be leery of invoking that provision on detention, which clearly is not, that allowed detention for anyone for several crimes other than murder. And this court ruled that with respect to those, it has violated the Organic Act and is not proper. So I don't know that you should rely on the specific detention provisions of that statute when it deals with non-first degree murder defendants.
Well, yes, so if the court decides that that restriction still applies here, then that's what we'll have to go with. But this particular statute is still active for other dangerous crimes. The statute throughout refers to pre-trial detention, and revocation of bail while someone's awaiting trial would be pre-trial detention. In fact, the legislative intent that this apply to pre-trial detention is found within the section where they refer to the government's ability to move for this pre-trial detention hearing if that party has already been released. The only way that someone can be released, already previously been released, is that they are already out on bail.
Yeah, but you're still, I think, referring to pretrial detention for non-first degree murder defendants. And you're using that detention, which we have said cannot apply, where you have the Organic Act that says that all persons are available on sufficient assurances, except for first degree murder, where the proof is evident and the presumption is great.
Well, here the consideration is not his initial bail. What we're looking at is someone who was already out on bail, who then violated the conditions of his pretrial release.
I understand what you're saying, but you're still going back to detention and pretrial detention. And if you are saying that this statute authorizes someone to be, the bail to be revoked, I don't believe that this would allow you to have pretrial detention. So, maybe there are other authority, inherent authority or otherwise, that authorizes the court to revoke bail where its conditions are not satisfied. And as Justice Swan put out, although I wouldn't emphasize the may so much because, it's the same. You may be, your bail may be revoked and you remanded to custody. And that is exactly what happened there. It may happen and it did happen, so.
Well, the government would argue that those same concerns, because when this court addressed that particular section and their concerns about detention, those we're looking at initial bail consideration. If this court chooses to also apply the same standard, the same concerns to pretrial bail revocation hearings, then we are asking that the court then provide us with some guidance. We don't have a particular statute dealing with bail revocation. Although the appellant asked us to apply section 5-1, rule 5-1, that rule does not address detention. It addresses forfeiture, which is not applicable here, and it addresses increasing bail, which is also not applicable here because here Faustin violated the terms of his pretrial release. He was not demonstrating that he is about to abscond, and he did not fail to appear. So those particular sections don't apply.
Attorney, let me ask you a question. This guy, I believe that he was, whereas there's some overtures that, well, because he is a part-time boat captain, he might be a flight risk, which has not been proven. He has musical, he plays music. He wants to go to church and he wants to a little bit more leeway. But let me ask you this though. He is in jail now. And right now, if he's in jail for going on 7 months, the only thing that he has done is a curfew violation. The judge had warned him that if he does violate his curfew, that he may go to jail. So he's not with Mr. Shahil, but he's going to Miss Fred's apartment. After 7 months, suppose he doesn't come to, so here we have somebody that's in jail and he's incarcerated, and that there's no time limit as to how long he's gonna be in jail. He may be in jail running into next year, unless we have a jury trial or unless this court does something to release him. And there's a plethora of other penalties that could have been imposed. Am I correct? I mean, she could have, the judge could have given him 30 days in jail for the curfew violation, 15 days in jail, 2 months in jail, 90 days in jail. But he has an indefinite sentence, no limit. And you can go on and on. So he can be in jail for 1.5 years, maybe 2 years, because I don't see, unless we do something about it, he could be in jail for a long time. And the only thing that the curfew, not all curfew violations are curfew violations. Mrs. Fred said that I depend on him financially to assist me with my living expenses. She has 2 other children and she has a 3rd one for him. She seemed to depend on him. Now, we don't know why he was there in violation of the curfew or any reason why, but isn't it seem that this man is in jail without a conviction, and a misdemeanor conviction, which less than 1 year or 90 days or whatever, he can be in jail for more than 1 year on a curfew violation. And he has not, that I know of in this record, committed any crime in the interim. And apparently, there is so many other penalty that the judge could have imposed, like a fine in conjunction with a short 30-day sentence or something of that sort. But to leave him languishing in jail, like a common criminal, which he has not have a conviction yet, and he may be in jail for longer than a misdemeanor, because everything now hinges, or the only relief he has is when the court's calendar allows for his case to come to trial. That's what he is facing. So does not seem, given the penalties that other people that have violated any kind of pre-sentence release, I mean pre-trial release. For a pre-trial release and a violation for curfew, to have someone in jail could run more than a year does not seem kind of, there's nothing in unfair, there's something unfairness about that.
Well, I want to quickly point out that Faustin was arrested for a dangerous and violent sexual crime against a minor, so it wasn't a misdemeanor.
No. I'm saying that a misdemeanor, a person convicted of a misdemeanor, which would be less than a year, he could very well be in jail longer than those people that commit a crime that have been convicted. Because remember now, pre-trial, there is a litany of things for pre-trial detention or denial of bail. And we go back to, again, what Attorney Christian said, the least restrictive, once murder is not involved, the least restrictive things, and everything must be taken on a case-by-case basis. You know, flight risk, what is a danger to the community? Is he going to be able to show up for trial? Is he going to is he going to perhaps commit another crime or harass the witnesses or the victims? All those things could go into consideration. But was there a whole lot of consideration given by the judge when she remanded him for an indefinite sentence or until trial?
Well, I want to point out that the people have not filed any continuances, and I do believe Attorney Christian did attempt to point out that the most recent continuance was filed by the people, and so the court knew that trial was imminent. One of the reasons I would ask, the government would ask that 3504A apply is because it does guarantee that, or something similar fashioned by this court, it does guarantee that any person detained pursuant to that code shall be placed on an expedited calendar. You could also hold that the 60-day limit that was previously found to be invalid when applied to bail revocation.
Hold on, Attorney. Am I correct that there was something in this record, that a comment by the court that suggested that whatever evidence that was collected in this case up to a particular time had not been sent away for analysis?
I'm unclear on the status. I know that it was at this point, I believe it has been sent away. I don't think it has been produced yet, but.
Okay, but at the time that the judge or the court made that comment, it had not been sent away. And apparently the court was very much upset and bristled at the fact that after all this time, the evidence had not gone away yet, so that we can move on to trial. We don't know when it's going to be coming back, but all we know is that he's going to be in jail unless this court does something. He's going to be in jail and heaven knows when they're going to get it back.
Well, he can always file a motion for pretrial release based on delay of trial. That was a very well-written Superior Court opinion under Velasquez. Also, if this court does apply 3504A, they can reconsider the application of the 60-day limit on detention, and that would resolve any concerns that someone is being detained indefinitely after a bail revocation.
So then what you are suggested that it is incumbent upon Attorney Christian, who had a third motion for release pending, and he said it might become moot, but he should file a fourth motion for release and point out to the court the protractedness of this detention in pre-trial for someone that well, he has not been convicted of anything, but he's up there. His colleagues are the criminal element, living day to day 24/7 with a criminal element. and he has not been convicted of anything, at least not yet, except that there was a foregone conclusion that the violation of the curfew. Weighing all of that, and 7+ months already, and only God knows when again that if he's ever going to get out before pre-trial, I mean before trial, does not seem a little harsh.
Well, before the court rules on a motion to modify and the defendant isn't detained, there it would be considered as a denial. The court did not rule on it. It was not a claim. Now that he's detained, if Attorney Christian were to file a motion saying, hey, what's the delay? Now, the delay probably wouldn't count here since the delay was at the request of the defendant. But let's say if there has been significant delay, then that would actually be a claim. And those are appealable.
In other words, he should file for like a speedy trial on the United States Constitution. He should file for an Organic Act. He should file a motion for immediate trial.
Well, his motion would be for reconsidering the condition bail. And so then the court would come to that, unless the court applies the 60-day limit on detention. Again, we have concerns with how the section applies to initial bail consideration, but it has not yet been viewed in light of pretrial revocation of bail consideration. And I do believe it would be a really good standard to apply here. The federal courts already have standards for revocation of bail. Almost every state appears to have a statute addressing revocation of bail. And we argue that we also have a statute already addressing revocation of bail.
All right. Okay.
So any question, 3 minutes.
Oh, something's wrong. I could see his.
Yeah, you need to unmute.
After 3 years, you'd think I know to unmute.
Oh yeah, okay, all right, I can hear you
My
now.
apologies. First, with respect to the remedy that Mr. Faustin chose to pursue, the rules of this court, as well as 4 VIC 33, provide that he can immediately appeal, and that's what he chose to do. The pending motion that had been pending since April, unopposed, was just sitting there. It was not denied until Judge Francois denied it as moot after she revoked bail. So, we used the rules that existed and the statutes that existed. How he chooses to pursue it is up to Mr. Faustin, not to the people. 2, to the extent that 3504A provides procedures for addressing these matters, I would submit that it's been supplanted by the rules of criminal procedure. Rule 46A plainly says pretrial release and detention matters are governed by Rule 5-1. And 5-1 spells out what the court is supposed to consider in releasing a defendant. Now, I agree with the Chief Justice. If the order is violated, then we have a civil contempt. And this court has ruled many times what the civil contempt standard is. The trial court did not have to deal with that because we conceded there was a violation of the curfew statute. The problem is the remedy. It doesn't fit the violation. The language used by the trial court in its oral decision and its subsequent written decision seemed to be very concerned, as was pointed out earlier, about Mr. Faustin being around minors, and in particular minor females. But the trial court set a very specific provision. He cannot be around them alone. It never strictly barred him from doing that. And I would submit they couldn't do it from doing that because that would prevent him from seeing his own child. And I don't believe that that would be constitutionally sound. There was no evidence, again, that he was ever alone with any minor. That's simply not in the record. Mr. Julius saw Mr. Faustin in the Loveland area after 6 p.m., it was close to 8 p.m., on one single night. He asked his children about if that was Faustin. They said yes. That's it. There's nothing else here. And for that, Mr. Faustin has been in jail for 9 months. Yes, he did file a motion for continuance, but it actually grows out of this improper incarceration. I can't go into more detail than that because it's filed under seal per the order of the court. But, you know, at essence, Mr. Faustin should never have been in jail. That is the point of this appeal. And if this decision is allowed to stand, what it means is that there is no individualized consideration as to the person and the circumstances, which would be
So
totally
you're
contrary.
saying that the court cannot revoke bail where someone violates the conditions of release?
Oh, so the court can if those conditions, if those circumstances are there. But as I said, it has to be an individualized decision as to the circumstances and the individual. There is nothing in the record that shows that Mr. Faustin is an increased risk flight since his release or an increased danger since his release. Nothing.
Well, there's
So-
something in the record that shows that he can't follow the court's release conditions.
It shows that on one night, a night that they couldn't even identify by date, Mr. Faustin was out beyond the curfew. That's it. And for that, a complete revocation without any express consideration of other standards similar to what's suggested in the ABA's pretrial release standards, particularly standard 10-5.6. There has to be some weighing of that. Otherwise, what is going to happen is that every time there is a release condition violation, the whole individualized consideration that this court has mandated in Davis and Moran goes out the window. And I don't believe that that's what the court intended. I think the court intended that if there is a violation, then the punishment, whatever that is, in fact, not even the punishment, the duty of the court is to
So
see.
you don't see a difference between the initial release and a violation of those conditions and the person is then remanded. You are saying that because this is not first-degree murder, that the court can never detain someone without setting bail, basically. So what
I think that's a legitimate argument, and I don't think it's a decision the court needs to reach in this instance on this record. But I think that's a legitimate argument because this court has also said, bail doesn't have to be reachable. But that's not detention. That's a different standard. What I'm saying is under the circumstances presented here, there was an abuse of discretion and that a proper application of the contempt standard and Rule 5-1 clearly show when applied to the facts that the trial court went way beyond its discretion in remanding him indefinitely pending trial. I believe my time is expired, so I thank your honors for this opportunity.
Oh, I can't hear the chief. The chief was talking, but I couldn't hear him.
Yeah. No, I muted.
I can hear
because-
you now. I can hear you now.
No, I'm sorry for that. I muted because someone came into the office, but
Okay.
yeah, so I was saying that the matter, well, I was asking if Justice Swan or Justice Corbett had any other questions.
No, I don't have any
I
other
have no
questions.
other questions.
Very well. Okay, thank you, Attorney Christian and Attorney Myers. The matter will be submitted, taken under advisement.
You have a good day.
Thank you,
So
your
with that,
honors.
that concludes our hearing oral arguments for today, and we will now adjourn.
Okay.